People versus Jack Cooper, case number 255061.
Ready, Your Honor. Thomas Seeger, and on behalf of Mr. Cooper.
Ryan Ziegler on behalf of Your Honor.
Thank you. The record should reflect Mr. Cooper's present here in the courtroom today.
Gosh, I'm sorry.
This is set for initial, or no, status conference. Mr. Seeger, can you tell me where this file stands?
Your Honor, it's my understanding that Mr. Cooper is going to tender a plea to one count of possession of methamphetamine with no individual offender. In exchange, all other counts would be dismissed and enhancements.
Thank you, Mr. Ziegler.
It's an accurate statement for the offer, Your Honor.
Okay, Mr. Cooper, have you had an adequate opportunity to go through this plea with your attorney, Mr. Seeger?
Yes, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you. Mr. Cooper, are you currently on any kind of probation or parole?
No, sir.
All right, and you understand that by pleading guilty to possession of methamphetamine, that the maximum possible penalty you could face would be up to 10 years and or a $15,000 fine?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. Do you understand that?
Yes, Your Honor.
Has anybody threatened you with anything to get you to plead guilty?
No, sir. No, Your Honor.
Has anybody promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty to this charge because you are actually guilty of the charge?
Yes, Your Honor.
The information I have indicates this happened back on March 27th of 2025. Is that the correct time frame?
Yes, Your Honor.
On or about that time, were you present here in Kalkaska County?
Yes, Your Honor.
While you were here in Kalkaska County, did you have possession of some methamphetamine?
Yes, Your Honor.
Did you know that that's what that was?
Yes, Your Honor.
Did you have any legal right to have any amount of it at that time?
No, Your Honor.
Thank you. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Cooper, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. It's important between now and then that you stay in touch with Mr. Seeger so that you're prepared for that hearing. When that is set, you'll be notified of the date and time of that hearing by the court by mail. Ms. Wagner, do you want Mr. Cooper to come over to your office here after this hearing?
Yes, Your Honor. Thank you.
So, Mr. Cooper, you just need to check in with the probation department next door. They're in the just right across this covered way here. So stop in there right after this hearing, okay?
Yes, sir.
Mr. Ziegler, anything further on this file?
No, Your Honor.
Mr. Seeger?
No, sir.
Okay, that's all for today. Thank you.
Thank you, Your Honor.
An added charge.
No,
Okay, it's count one.
cut one, no.
Okay, thank you.
People versus Wendy Wilkes.
Ready, Your Honor.
This is file number 255068.
Ryan Ziegler, on behalf of the people.
Thomas Seeger agreeing with on behalf of Ms. Wilkes.
Okay, and it looks like this is a final status conference. I did receive a police report. Do we have a no contest plea, Mr. Seaver?
We do, Your Honor. Your Honor, I don't know if the court recalls, but at the previous hearing, we attempted to enter into a plea. We were unable to create a factual basis. I did speak with the prosecuting attorney. He did furnish the court with a copy of the police report. To the extent that the court, after having had an opportunity to report, believes that a no contest plea would be possible, we would ask the court to accept that. If in the alternative, the court does not believe that a factual basis can be met by virtue of the police report, then we'll circle back and determine what we're going to do with it.
All right, Mr. Ziegler, do the people have any objection to the no contest plea?
No objection, Your Honor. It would be based on potential civil liability, and the plea would be to false pretenses, 200 to 1,000. So one investigation.
A 1 year
Correct.
restitution?
The restitution has been resolved, Your Honor. The bank has taken care of that.
Okay. All right, so let's go through the hearing. I did, Mr. Seeger, I had a chance, and I when I saw that police report, I recalled that hearing that we had when I was inquiring of Ms. Wilkes. So I did have a chance to review that police report. And the statute under count 1, which I would be taking a factual basis to, as well as some case law. It's my view, based on the information contained within the report, that it would support a finding of guilt, but I'll inquire of both you and Mr. Ziegler as part of the plea process here. Before we get to that, Ms. Wilkes, have you had an opportunity to talk to your attorney about this plea agreement?
Yeah,
And is that how you want to proceed today?
yes,
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes,
Thank you. You can lower your hand. So I think we talked last time, you're not on any kind of probation or parole, is that correct?
correct,
And you understand, again, that the maximum possible penalty in this case would be up to 1 year in jail.
yes,
Okay. Do you remember that hearing that we had last month?
a little bit,
Okay, I'm gonna go through your rights with you again, then, just to make sure that
Okay.
you fully understand. So you have the right to have a trial, you have the right to be tried by a jury, you have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand that you have all of those rights?
yes,
And you understand that if you plead no contest today, that you're going to be giving up all of those rights?
yes,
Okay. Has anybody threatened you with anything to get you to enter this plea?
no, Your Honor,
Has anyone promised you anything other than what we've discussed here on the record?
no,
Is it your own free choice to enter this plea?
yes,
Okay. And again, as to this charge, which is, again, false pretenses, Mr. Ziegler, is that what you said?
Yes, Your Honor, 200 to 1,000.
Okay. What is your plea to that charge today?
no contest,
All right, so I'm going to mark as Court Exhibit 1, the police report that was submitted by Mr. Seeger, and I believe that's a Kalkaska County Sheriff's Department report. I reviewed that. In my view, the statute would require, and in this case, I think that the element is the knowing or intentional element. And having looked at the case law and the statute, I believe, it's my view that the standard is that either Ms. Wilkes knew it was false, altered, forged, or counterfeit, or should have known or had reason to know. And I think given the nature of the surrounding circumstances, the amount I think a reasonable person would have or should have known that this was not a legitimate transaction. And so it would be on that basis that I think the facts within the police report would support a finding of guilt. But as to that factual basis, Mr. Ziegler, have you reviewed that police report?
I have, Your Honor.
And what's your view as to the factual basis?
I agree with the court that the factual circumstances surrounding how she received the check and the amount of the check would provide good grounds to believe that she should have known that that check was fraudulent.
Mr. Seeger?
I agree, yeah.
Okay. All right, so with that, Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No.
Mr. Ziegler, are the people satisfied that the court has complied with statute, court rule, and the taking of this no contest plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
All right, the court finds that the plea is knowing and voluntary. Again, I'm admitting that police report is court exhibit 1 and attaching that to the file. The court finds, based on a review of that there is an adequate factual basis to support a finding that Ms. Smith is guilty of this added count 2. The court will accept a no contest plea. How did we want to proceed with sentencing? Mr. Ziegler, are the people going to be asking for jail time in this matter?
No, Your Honor.
Mr. Seeger, did you want to proceed with sentencing today? Is that something you talked with Ms. Wilkes?
Yes, Your Honor, I would prefer to go forward with sentencing. If the prosecuting attorney is not inclined to ask for jail, I would ask for immediate sentencing, and we would form a pre-sentence report.
Okay, Ms. Wilkes, do you have any objection to that?
No,
Did you want to talk to Mr. Seeger at all before we do that?
no.
All right, I feel like based on the fact that I've reviewed this police report as part of the no contest plea, which provides a lot of very detailed information. Also based on Ms. Wilkes' testimony at the last plea hearing, I feel like I have an adequate factual understanding of what happened in order to formulate an appropriate sentence. So I don't have an objection proceeding with sentencing. Mr. Ziegler, in terms of allocution on behalf of the people.
Your Honor, the court's read the report. I think it's a fair and accurate summary of what occurred. Ms. Wilkes at the last hearing testified that she honestly did not know that the check was fraudulent. The statute's quite clear that that's not actually required, just that she should have known. I think any reasonable person in her position should have known that there was something illegal or at least suspicious going on. Under those circumstances, I can't say what Ms. Wilkes knew or didn't know affirmatively. But be that as it may, Your Honor, she's made arrangements to settle the debt with the bank. I think she's taken out a loan to repay the bank, and then the bank is recollecting that loan. So all the money's been taken care of. I think Ms. Wilkes now understands at least that it was a very poor decision. I think it's something she's unlikely to repeat in the future. And so I would just ask the court to sentence her to fines and costs.
To your knowledge, does Ms. Wilkes have any prior criminal history or history involving similar charges?
Ms. Wilkes has no criminal history of any kind, to my knowledge, Your Honor.
Okay, thank you, Mr. Seeger.
Your Honor, this matter having been reduced to a misdemeanor is a non-serious misdemeanor. Additionally, Your Honor, to that end, Your Honor, she has made arrangements for the restitution to be paid, so that matter is resolved. And I'm not really sure what to make of this. It really probably does fall on the question of what she should have known, not whether or not she actually knew. So I do think that sometimes people maybe don't fully appreciate things, or maybe they don't think things through clearly, and I think that this may have been that situation. But she has no prior criminal history. She has made right with the debt. I would just ask the court to full cost of fines.
Thank you. Ms. Wilkes, anything you wanted to say today?
No.
Okay, again, I'm very familiar with the facts of this case, having read through the police report and listened to your testimony at the previous hearing. I agree with what the lawyers have said. I think this really becomes more of, I hope, a learning experience for you going forward, not to necessarily accept everything that somebody says to you, and just to kind of use your own gut feeling and, kind of common sense. I have to believe that at some point during this, you had some kind of feeling that this just doesn't feel right, or this doesn't seem right, given the amount of money involved here. And if you didn't feel that way, then you need to be much more cautious yourself intentionally when somebody comes to you with a check for that kind of money and wants you to cash it and then give them back a substantial portion of that. That's just not something that people will normally do. Because you don't have any prior criminal history, because I tend to agree, I don't think you had any direct knowledge that this was a fraudulent transaction. Certainly nobody told you that or said that up front. Hey, this is illegal, but I want you to do it for me. That's not what happened here. I think you should have known that, but I think that's a mitigating part of this. There's different ways that the court can punish wrongful conduct. One of them, of course, is jail. The other is financial. And in your case, given your lack of prior history, given the circumstances here, I don't believe that jail is an appropriate sanction. I think that a financial penalty is adequate to impress upon you how you need to be much more careful in the future with these kind of situations. So the court is going to sentence you to fines and costs, $325 in court costs, an attorney fee of $350, state cost of $50, and a crime victims assessment of $75, as this is a misdemeanor. Because it is a misdemeanor, you're not going to get any written paperwork explaining to you what your appellate rights are, but you can seek an appeal of the sentence. If you wanted to do that, you would need to file that paperwork within the next 21 days. If you have more questions about that, Mr. Seeger would be able to answer those for you. Other than that, when you leave court today, you just need to go over to the clerk's office next door to make arrangements to pay those fines and costs, okay?
Okay,
Good luck to you going forward.
thank you.
Can I get the PAT code for that?
$750.2183A.
Thank you.
People versus Dunn, Carlos Dunn.
Yeah, he's lodged, so I'm not sure if he's up. Mr. Trepanier is in the courtroom now.
Okay. He's here. Okay, so this is People versus Carlos Dunn, file number 255088. The record should reflect Mr. Dunn's present here in the courtroom today. If I can have counsel.
Ryan Ziegler, that the people here.
Tom Seeger, friend with on behalf of Mr. Don.
How did we want to proceed in this file today, Mr. Seeger?
Your Honor, I would ask the court for a brief adjournment, maybe 60 days or something of that nature. There was a file that was part and parcel of the original offense date that for whatever reason was not initially charged, but then was. And so there is a complaint that is currently pending in district court, was arraigned yesterday. So I'm not, I don't recall when the preliminary examination date is, but then that file would have to catch up with this file. The current offer is somewhat tied to the new file, but I don't have the discovery yet, so I haven't had a chance to review it. So if the court gave us, I guess it's 21 days to the preliminary examination, Your Honor, and then it's probably 30 days to get in the circuit court. So that if the court gave us 60 days or somewhere around that time period, Your Honor, perhaps we'll be able to resolve it at the next date.
Okay, any objection to that, Mr. Ziegler?
No, Your Honor.
Okay, so I'm just going to order then that we set this for a status conference plea hearing in 60 days. I'm going to order that once that new file is bound over, that also be assigned to me, and we'll set that for hearing at the same time as this file. Anything further on this file today, Mr. Seeger?
No, sir.
Mr. Ziegler?
No, Your Honor.
Mr. Dunn, do you have any questions about how we're going to proceed with your cases?
No, sir.
Thank you. That's all for today.
Thank you.
People versus Trepanier, case number 255091. Like Mr. Trepanier is present here in the courtroom. If I could have counsel.
Deeply honored.
Thomas Seeger, Grand Meth, on behalf of Mr. Trepanier.
Mr. Seeger, what's the status of this file today?
Your Honor, I just received some video discovery from the prosecuting attorney's office. I did forward that to the client. We're both still in the process of reviewing it. There's quite a bit of video evidence that was attached to it. So if the court would give us a brief adjournment so that we can review it all and then determine.
Mr. Ziegler, any objection to that?
No, Your Honor, it's correct. I provided a lot of video on Thursday of last week.
Mr. Trepanier, do you have any objection to that?
No, sir.
Okay, so I mean, that's reasonable to me if you just received that kind of discovery, Mr. Seeger. I think it's reasonable that you would need to go through that and discuss that with your client before you'd be ready to proceed. So we'll set this for a status conference and plea hearing in 30 days. Mr. Trepanier, it's just important that you stay in touch with Mr. Seeger so that you're ready to proceed at that next hearing, okay?
Yes.
All right, thank you, that's all for today.
Your Honor, I think Ms. Way is here, but could I have 5 minutes just to speak with her briefly?
Sure, yeah, let's take a short break. We'll come back on the record at 9:30. back on the record in People versus Amanda Way. This is file number 2454958 and 255078. The record should reflect that Ms. Way is present here in the courtroom today. If I can have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Secret agreement with on behalf of Ms. Way.
Thank you. This is the date and time set for sentencing in both of these matters. One is sentencing on a probation violation. The other is on the new charges. Ms. Way, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Seeger?
Yeah, I did.
Okay. And Mr. Seeger, are there any additions, deletions, or corrections?
You're not here.
Any challenges to the scoring on the new charge? Okay. Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I think I largely agree with the report. Yes, I author. I think Ms. Way was on probation at the time she committed this offense. She was on probation for very similar conduct. She's had opportunities on probation before. They have not panned out. The idea of putting her back on probation at this point makes very little sense. The only question in my mind then is how much jail is deserving in this case. I think a sentence of 12 months is at the lower end of the guidelines, Your Honor. It doesn't put her in prison, but it does impress upon her the seriousness of her actions. I think it's an appropriate sentence under the circumstances, especially given that she was on probation and she's in front of the court for a probation violation. So I think as to the new file, that's the sentence that I would recommend, Your Honor.
Thank you, Mr. Seeger.
Your Honor, I've had a lot of opportunities to speak with Ms. Way, and she has struggled with addiction for a long period of time in her life. And much like many other people who have substance abuse problems, I think that simply because you're on paper doesn't necessarily change the fact that you have a substance abuse problem. And it's probably no different for Ms. Way. And so she had indicated that she had had relapses, that she was struggling with housing, finance, everything. I think things somewhat spiraled downhill for her. But to that end, Your Honor, having been incarcerated for a period of time, I think her mind is a lot clearer. She's expressed a want to remain substance abuse free. She's been looking into getting into NAAA. She's hopeful that whatever sentence the court imposes, that hopefully it will allow her to get into treatment to the extent that she becomes eligible. I would agree with Mr. Ziegler that a county time sanction is appropriate. In what amount, I would defer to the court. But she did indicate that hopefully this is a last stop for her. She does recognize that she continues to come back to court. It can only get worse for her. But she's not a person who's selling drugs. She's a person who has a drug addiction. And it's unfortunate because a lot of people find themselves in this position. And then when they're incarcerated for long periods of time, sometimes I feel like that it only makes their situation worse. Not that it's not necessarily deserved or necessary. But when they come out, they really don't have a lot of different things. She did indicate to me today that she has distanced herself from other people who have similar like afflictions, which hopefully will be helpful. She indicated that she has aspirations of getting into Bear River when she's released, whether it's by virtue of the sentence or after her sentence is completed. So I am optimistic that she will be able to make better decisions going forward. Hopefully the time that she spent incarcerated, for lack of a better phrasing, Your Honor, is somewhere of a dragging out period for her. But she's hopeful that she'll be able to remain sober and going forward. Hopefully we won't have any further interactions with her.
Thank you. Ms. Way, anything you wanted to say today?
Just, I mean, he basically touched the topics I was gonna speak on. This is my last go round. I mean, drugs have they've taken everything from me, and it's time to, get it right. So that's all.
Okay. I did read through the report, so I'm familiar with the circumstances of the new charge. Of course, I was familiar with your underlying case that you're on probation for already. And also all the personal information, background, and so forth regarding you and your circumstances. And given the nature of the new offense here, I certainly don't think this is something that calls for prison time. I think it calls for a sentence at the lower end of the guidelines. This was strictly use. You didn't have a large amount. the biggest downside is it sounds like at the beginning of the probation that you were having some successes there, and then relapsed, and then I think just kind of completely went off the rails. And so I don't think it's appropriate to impose more probation. It doesn't seem to have been helpful to you in the past. I do think, if you can do it for a month or 2 months, you can do it for 6 months or a year or longer than that. A lot of times people relapse and then they can give up completely and just go 100% the other way. You can relapse and then get right back on the right track again. And sometimes it takes many times, as you're probably aware, people relapse. It's part of the recovery process, but it doesn't mean that you should just give up. If you do, it's time to get back on the wagon, so to speak. And I hope that you do seek out treatment and those kind of things on your own, not because you're being ordered to or because it's a condition of probation, but because you just don't want to do this anymore. So I hope that you do that. The guidelines here are 5 to 23. I think, again, a sentence at the very low end of the guidelines is appropriate given the circumstances. So the court is going to sentence you on the new file to 5 months in the Kalkaska County Jail. You do have credit for 84 days served, a crime victims assessment of $130, court costs of $325, attorney fees of $50, and a $68 state cost. As to the probation violation file, you do have 180 days credit, so the court is going to sentence you to 180 days in jail with credit for 180 days served. The court will discharge you unsuccessfully from that probation and preserve any outstanding fines and costs. You do have the ability to seek an appeal of both of these sentences. Mr. Seeger, if you can have Ms. Way acknowledge your seat.
For the record, acknowledge receipt of her appellate rights. She's executing a copy of the same thing.
Good luck to you going forward, Ms. Way. Do you have Ms. Merritt present?
She is now present.
We're a little bit ahead of schedule. I also, Mr. Corbin's going to be by video. I don't see them connected yet, so let's take a short recess. We'll come back at 9:45.
Mr.
On the record in People versus Shelley Merritt, the record should reflect Ms. Merritt is present here. This is file number 255074. I can have counsel put your appearances on.
Ryan Ziegler, on behalf of people, Your Honor.
Thomas Seeger appearing with on behalf of Ms. Merritt.
And how do we want to proceed on this file today, Mr. Pursuit?
Your Honor, my understanding that the people have offered Ms. Merritt an opportunity to take one count of possession of narcotics, which we treated for 7411. Exchange the balance would be dismissed.
Okay, so that's pleading guilty to count one and the information.
Yes, Your Honor.
Mr. Ziegler?
Fair statement.
Ms. Merritt, have you had an adequate opportunity to talk to Mr. Seeger about this plea agreement?
Yes,
Is that how you wanted to go forward today?
yes,
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
yes,
Thank you. Ms. Merritt, are you currently on any kind of probation or parole?
No.
And you understand that by pleading guilty to count one, which is possession of controlled substance, that is a felony that carries with it a maximum possible penalty of up to 4 years and or a $25,000 fine.
yes.
With that in mind, what is your plea to that charge today?
Guilty?
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
I do.
And you understand that you're giving up all of those rights by pleading guilty today?
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means if you wanted to try to do that, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
I understand.
Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
Yes,
Are you pleading guilty because you are actually guilty of this charge?
yes,
So the date that I have indicates this happened back on April 26th of 2025. Is that the correct time frame?
yes,
And at that time, were you present here in Kalkaska County?
yes,
While you were here in Kalkaska County, did you have possession of the controlled substance fentanyl?
yes,
Did you know that that's what that substance was?
yes.
Did you have any legal right to have any amount of it at that time?
No.
All right, thank you. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Ms. Merritt, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, it's important that you stay in touch with Mr. Seeger so that you're prepared to go forward on that day. When you leave here today, you need to go next door to the probation office to make arrangements for a pre-sentence interview, okay?
Is that cost?
Did you have any questions at all? Mr. Ziegler, anything further that we need to address on this file?
No, Your Honor.
Mr. Seeger?
No, sir.
That's all for today. Thank you, Ms. Merritt. Okay, Mr. Corbin, if you can unmute, please. All right, sir, are you Adam Corbin?
Yes, sir.
Are you able to hear me okay?
Yes, Your Honor.
Okay. We'll go on the record in People versus Adam Corbin. This is file number 255093. The record should reflect that Mr. Corbin is appearing today by video from Wexford County Jail. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger, appearing with Mr. Corbin.
Okay, so Mr. Seeger, do we have a plea agreement?
Your Honor, it's my understanding that people have offered Mr. Corbin an opportunity to plead to joint count of felonies of assault and exchange his efforts to dismiss.
Mr. Ziegler?
That's a fair statement, Your Honor.
Okay, so Mr. Corbin, under this plea agreement, you would be pleading guilty to one count of felonious assault. All the other charges would be dismissed. Have you had an opportunity to talk to Mr. Seeger about that?
Yes, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Corbin, are you currently on any kind of probation or parole?
No, Your Honor.
And do you understand that the maximum possible penalty that you could face for felonious assault is up to 4 years and or a $2,000 fine? Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
Right now you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
And do you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal by leave, and that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty today?
No, Your Honor.
Has anyone promised you anything other than what we've talked about here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty of this crime?
Yes, Your Honor.
This incident happened back on February 25th of 2025. Is that the correct day?
I think so, Your Honor.
Okay. On that day, were you at your home here in Kalkaska
Yes, sir.
County?
Yes, Your Honor.
Okay, and the police came to your home on that day, is that right?
Yes, Your Honor.
Okay, and they were there investigating a potential fire, is that right?
Yes, Your Honor.
Okay, and did you know that they were police officers?
I don't remember, Your Honor.
Okay.
I
Do you
just-
remember having an altercation with those police officers?
Yes, Your Honor.
Okay. And during that altercation, did you have a knife in your hand?
Yes, Your Honor.
And at some point, did you try to assault one of those officers or multiple officers with that knife?
I was trying to get him out the door, yes, Your Honor.
Okay. All right, Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Counsel, are you both satisfied that the court has complied with statute, court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Mr. Corbin, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We're going to set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, somebody from the probation department is going to be in touch to prepare a pre-sentence report. Mr. Ziegler, anything further on this file today? Mr. Seeger?
No, sir.
Mr. Corbin, did you have any questions at all?
No, sir.
Okay, thank you. That's all for this hearing today, and the court is going to disconnect at this time.
Thank you, Your Honor.
Okay. Mr. Travis, I know, it looks like Mr. McGuire is also going to be from Wexford County. Do you have anybody in the courtroom that we can take?
Mr. Hines is here, Your Honor.
Okay. Court will call People versus Jerry Hines, file number 255079. The record should reflect that Mr. Hines is present here in the courtroom today. And Mr. Travis, how do we want to proceed on Mr. Hines?
Your Honor, we had adjourned last month for some follow-up on some investigation. And in speaking with Mr. Ziegler and Mr. Hines, there's not been any follow-up from that officer. Mr. Hines has struggled to get him to return phone calls. Apparently his voicemail is not set up, and when he calls dispatch, he's generally not on. I did ask Mr. Ziegler if we've gotten any reports, and he has not gotten any reports. I'm a little generally concerned about that, but we still at this point would like to see what's happening with that investigation. It does, at least from the defense perspective, have a lot to do with how we're going to proceed, because there's some allegations that a number of items were stolen from Mr. Hines's home. And even probably most concerningly, some allegations that one of the alleged victims was passing his checks, what we would assume would be illegally.
Okay, Mr. Ziegler,
I don't have any objection to the adjournment, Your Honor.
do you have any idea what the holdup is with communications with the officer? Is that something outside of this file?
It's technically unrelated, Your Honor. There's a separate investigation.
Okay.
It's into the victim and into the victim of this case against the defendant in this case. So the parties are flipped. The village is conducting that investigation. I talked to the officer via email 2 or 3 weeks ago. I was informed that investigation was proceeding. They were looking into some video. They were following up on things. I have not heard anything since then. I will follow up with that officer and see if there's any updates.
Okay, but it's not a matter of discovery in this case that's being sought.
It's being sought in this case, Your Honor, but it's not related to this case in the sense that I'm sure it's meaningful to the defense, but I don't believe it has any relevance to the underlying allegations in this case specifically.
Okay, whatever happened there wouldn't be a legal justification for the action.
I don't believe so, Your Honor.
All right, has there been a plea offer in this case?
Your Honor, I think we were waiting on this matter before we discussed potential resolutions in earnest. I don't think we've made a formal plea offer.
Okay, all right. It sounds like in either case, Mr. Travis, that you'd be justified in wanting to have that information for Mr. Hines before plea negotiations here. Let's say, even if it doesn't affect the relevance of the underlying charge, it certainly could affect that part of it. So we'll adjourn for 30 more days. If at that point we're going to need to move forward. So, Mr. Hines, do you have any questions at all?
Okay.
All right. Just make sure that you stay in touch with Mr. Travis, okay?
Sure.
Okay. Thank you. That's all for today.
Thank you, Your Honor.
Do you have anybody else in the courtroom?
Your Honor, I have one.
Okay, we can take that case. People versus Stephanie Clay, file number 255083. Record should reflect Ms. Clay is present here in the courtroom today. If I could have counsel put your appearances on in this file.
Ryan Ziegler, yes, Your Honor.
Thomas Seeger appearing on behalf of Ms. Clay.
Mr. Seeger, can you tell me the status of this file?
Your Honor, it's my understanding that Ms. Clay is going to tender a plea to possession of methamphetamine, which would be treating her as something.
Is that
Fair
correct?
statement, Your Honor.
Okay. Ms. Clay, have you had an opportunity to talk about this plea agreement with Mr. Seeger?
Yes.
Okay, and is that how you wanted to proceed today?
Yes.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Ms. Clay, are you currently on any kind of probation or parole?
I'm on a PR bond, but
Okay,
that's it.
okay. And have you had any kind of controlled substance conviction in the past?
No.
You understand that by pleading guilty to possession of methamphetamine, that's a felony that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine?
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear in the trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you have to ask for the Court of Appeals to hear your case. They can say no, and then that's the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this crime? Okay. The information I have indicates this happened back on July 21st of 2025. Is that the correct day? On that day, were you present here in Kalkaska County? And while you were here in Kalkaska County, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that was? Did you have any legal right to have any amount of it at that time?
No.
All right, Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Thank you. Ms. Clay, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We're going to set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your attorney, Mr. Seeger, between now and then, okay?
What's the address for my mailing on file?
What we have is an address on Cottage Street in Kingsley.
Oh, I definitely need to change that one.
Okay. Yeah, is that what you have?
I don't.
Oh, no, I'm sorry. Well, we have Cottage Street, then we have one on Gonier and Pike Lake.
I have Cottage Street.
Oh. What is your correct address?
4810 Western Avenue Southeast, Kalkaska, Michigan, 49646.
Thank you for correcting that. That's really important, so I'm glad you
Yep,
did
I
that.
will change
Oh,
it.
I was using a PO box, but I'm gonna be closing that soon, so I just wanted to make sure my mail's going to the other one now.
Nope, very smart. Thank you for doing that. And then the last thing you need to do before you leave court today is to go next door to the probation department and check in with them to set up a pre-sentence interview, okay? Thank you.
Your Honor, I would also note, and it's just a small thing, but on the docket, it's the same papers that I had stuffed into that file, so.
I
it's
just changed it.
Yeah, thank you. Okay, Mr. Travis, we have, I believe, Mr. McGuire. Mr. McGuire, if you can unmute on your end, please. And sir, are you Jonathan McGuire?
Yes, sir.
Okay, we'll go on the record in People versus Jonathan McGuire. This is file number 234847. The record should reflect Mr. McGuire's appearing today by video from Wexford County Jail. If I can have counsel put your appearances on.
Ryan Ziegler, yeah.
Kyle Travis on behalf of Mr. McGuire.
Mr. Travis, can you tell me the status of this case today?
Yes, Your Honor. It is my understanding that the prosecutor would offer if Mr. McGuire pled to an operating while intoxicated third offense, they would dismiss the misdemeanors and the habitual offender enhancement, and that Mr. McGuire would like to enter that plea.
Mr. Ziegler?
It's a fair statement of the offer, Your Honor.
Okay. And Mr. McGuire, were you able to hear that?
Yes, sir.
Okay, is that the plea agreement that you've discussed with Mr. Travis?
Yes, sir.
And is that how you wanted to go forward today?
Yes, it is.
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. McGuire, are you currently on any kind of probation or parole?
No, I am not.
All right, and you understand that by pleading guilty to operating while intoxicated as a third offense, that's a felony that carries with it a maximum possible penalty of up to 5 years and or a $5,000 fine.
Yes.
With that in mind, what is your plea to that charge today?
I will plead guilty.
So I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No,
Is it your own free choice to enter this plea?
it is.
Are you pleading guilty because you are in fact guilty of this charge?
Yes, sir.
So the information I have indicates that this took place a while ago, back on July 3rd of 2023. Do you recall that day?
I do.
And on that day, had you been consuming alcohol?
I have.
And after you consumed alcohol on that day, did you operate a vehicle on Rapid City Road here in Kalkaska County?
I did.
And did you have any blood or breath tests to determine the level of alcohol in your system at that time?
I did. They gave me, the roadside breathalyzer test.
Do you remember what that was?
Yes, it was 0.09.
Okay. Did you later have any kind of blood or other breath tests done?
Yes, I believe at the county when I got there, they gave me that breathalyzer, the big machine one that
Okay,
they have inside the county. No blood though.
okay. Were the results of that test above a 0.08?
Just slightly. It was less than what it was at the roadside test.
Okay, but it was still above the 0.08?
Yeah, I believe it was 0.08, like 7.8 or something to that effect, roughly right around there.
Okay, that second test that we've just talked about, do you have any reason to doubt the accuracy of that test?
I don't know, honestly.
Okay,
I believe they're to be more accurate than the roadside ones.
right. But sitting here today, you don't have any specific reason that you can point to as to why that wouldn't have been accurate?
No,
Okay. Had you previously been convicted of operating while intoxicated back in December of 2016 here in the 46th Circuit?
yes, sir.
And then also back in July of 2014 in the 20th Circuit?
Yes.
Okay. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Mr. McGuire, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, somebody from the probation department will be in touch with you for a pre-sentence report. And once that's prepared, you'll have an opportunity to go through that with your attorney, Mr. Travis. Mr. Ziegler, is there anything else that we need to address on this file today?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. McGuire, did you have any questions at all?
I do not, Your Honor.
Okay, thank you. That's all for this hearing today, and the court's going to disconnect at this time.
All right, thank you.
All right, our next file is People versus Armstrong. And Okay, we're on the record now in People versus Hiddle, two files, file number 244993 and 244994. And record should reflect that Mr. Hiddle is present today. Let's see. Number 244993. That's the sentencing file. That is set for sentencing today as a result of the jury trial that we held. I believe Mr. Hiddle was found guilty of the misdemeanor in that file. Is that correct?
That is correct. I'm driving without insurance.
Okay. So in terms of sentencing on that, Mr. Ziegler, the people have any allocution?
Not particularly, Your Honor, it's a misdemeanor. There's a presumption of court costs and fines. I have a lot of thoughts on the matter, but the court's not allowed to take into account acquitted conduct. So I would just ask the court to sentence the defendant to find some costs on that matter.
Thank you, Mr. Travis.
Similarly, Your Honor, we would ask the court to consider a fines and costs sentence. Also noting that Mr. Hiddle is not in the strongest of financial circumstances. And is obviously here and able to handle things, but has been struggling with housing and employment and transportation as of late. Thank you.
All right, thank you. Mr. Hiddle, anything that you wanted to say today? Okay, so I mean, obviously I'm well familiar with the facts of what happened in that case based on the testimony that came out during trial. I agree with counsel, given the nature of the conviction here, which is a misdemeanor. I don't find that any kind of jail time is appropriate. So the court is going to impose all the standard fines and costs. There are some of those, Mr. Hiddle, that the court can't do anything about, but there are some that I will give you the option of doing community service in lieu of paying those. But that's up to you. So in terms of fines and costs, the court is going to impose the state cost of $50 for misdemeanor, crime victims assessment of $75, and a fine of $200. And that fine is required by statute, not less than $200 fine. So the court will set that as the fine. And those are the ones, Mr. Hiddle, that you have to pay. The court is also going to impose $325 in court costs and a $350 attorney fee. The court will give you the option, Mr. Hiddle, if you do 40 hours of community service and you turn in proof of that to the clerk's office, then the court would waive the court-appointed attorney fee and court costs. You do have the ability to appeal the sentence. If you wanted to do that, you would need to file that paperwork within the next 21 days. If you have more questions about that, then you would be able, I'm sure Mr. Travis will be able to help you with that. Otherwise, when we leave here today, you need to go next door to the clerk's office to make arrangements to pay those fines and costs, okay? In terms of file number 2994, Mr. Travis, can you tell me what the status of that file is?
Yes, Your Honor. In the lead up to today's hearing relative to that, I've had some discussions with Mr. Ziegler. And it's my understanding that he would offer Mr. Hiddle a plea offer of an attempted resist and obstruct. And if he did accept that offer, Mr. Ziegler would also dismiss a district court trespass file that's in front of Judge Boudet. It is my understanding that Mr. Hiddle would like to accept that offer.
Okay, Mr. Hiddle, have you had a chance to talk about that with Mr. Travis?
Yes, Your
And is that how you wanted to proceed on that?
Yes, Your
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Hiddle, you understand that by pleading guilty to resisting or obstructing a police officer as an attempt, that the maximum penalty you can face would be up to 1 year in jail. With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all of those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty of this charge?
Yes, Your Honor.
So this happened back on October 22nd of 2024. Is that the correct date?
Yes.
Okay. And on that date, did you come into contact with Deputy Hall of the Kalkaska County Sheriff's Department?
Yes.
Where did that happen at?
I was Rapid City.
Oh, Rapid City?
Yes.
Okay. And was Deputy Hall wearing his uniform?
Yes.
Did you know that he was there acting as a police officer?
Yes.
And what did you do to attempt to resist or obstruct Deputy Hall at that time?
I believe I pulled my arm away from him.
Okay. Mr. Ziegler, are the people satisfied with the factual basis?
I'm satisfied with the factual basis. Your
Mr.
Honor.
Travis?
Yes, Your Honor.
Mr. Ziegler or Mr. Travis, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute, the court will not take on this plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. Hiddle, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of that charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Travis. Ms. Wagner, I'm going to request a misdemeanor PSI just with a rundown of what happened, during this incident. Thank you. So if you can just check in with Ms. Wagner at probation after you leave here today, okay?
Sure.
All right. Mr. Ziegler, anything further on either of these files today?
No, Your Honor.
Mr. Travis?
Nothing further. Your Honor. Thank you.
All right, thank you. That's all for today, Mr. Hiddle. Okay, Mr. Barnes, can you unmute there, please?
Can you hear me?
I can. Are you Joshua Barnes?
Yes, sir.
Okay. All right, we'll go on the record in People versus Barnes. This is file number 255075. The record should reflect Mr. Barnes is present today by video from Wexford County Jail. Council, put your appearances on.
Yes, people, Your Honor.
Kyle Travis on behalf of Mr. Barnes.
Mr. Travis, can you tell me the status of this file here today?
Yes, Your Honor. Mr. Barnes had waived his prelim based on an alternative offer from the prosecutor. And part of that offer is relative to, he's got a file from Charlevoix where we believe he's going to receive a sentence of 1 year. And if that is the case, the prosecutor would offer Mr. Barnes a use of narcotics, and that's what Mr. Barnes would like to do. I think in the alternative, that's the possession of analogs with the 1 year cap. With the alternative, the issue is Mr. Barnes has written Charlevoix a few times. It doesn't appear that they've taken any response. At the first time I called them about it, they indicated they hadn't gotten the writ, and that's Mr. Barnes sent another writ after that. So we don't know what's happening with that piece, but eventually Mr. Barnes would like to accept that use offer. I have spoken to his public defender up in Charlevoix, and he indicated that he can't see anything about the 1 year happening, given some circumstances in that case. That was the recommendation. And then Mr. Barnes didn't show that sentencing. So we're fairly confident that's going to happen, but it hasn't happened yet. So today, I guess we'd be asking for an adjournment, but we'd also be asking the court to consider granting Mr. Barnes a PR bond. Not necessarily because Mr. Barnes thinks he's going to get out, but we believe that would push Charlevoix to have to take action and come get him or do something. He has been in, it appears since the end of June, at least, given my appointment paperwork. So that would put him at a little over 3 months of time incarcerated, approaching 4 months. So it's not as though he's not served any time in custody, Your Honor. And Mr. Ziegler's going to say he doesn't want him out on a PR bond, but we aren't asking for the PR bond to truly get him out. We want to just make Charlevoix have to act. Thank you, Your Honor.
All right, Mr. Ziegler.
Your Honor, I don't dispute any of the factual claims that Mr. Travis is making. I don't have any objection to the adjournment being requested. The plea offer is somewhat contingent on what's going on in Charlevoix. The charges of possession of narcotics have before. I wouldn't be making a use offer unless I had already known that he was going to be subject to a 12-month sentence. That's the whole purpose of the offer. It seems like that's going to occur, but I don't know that until he's actually sentenced. In terms of the request for bond modification, Your Honor, Mr. Barnes has a lengthy criminal history. I don't know whether Charlevoix has a hold on him or whether they would come and get him subject to that hold if he was PR'd here. And I'm not comfortable stipulating to a PR bond if there's any chance that he would be able to walk out of the jail and be free in the public pending both of these cases. So at this time, I would oppose any modification to the bond.
All right, the 1 year, if he does get that 1 year sentence in Charlevoix, I mean, would that run concurrent to any sentence in this case?
Correct.
That is everyone's understanding.
All right. So, okay, you know, Mr. Barnes has sat for quite a bit of time on this file. It was bound over in July. The court, we didn't receive notice of the bind over, and that's an error on the court's behalf. Or the system's behalf. Otherwise, we would have had Mr. Barnes for a hearing in August, I mean, much sooner. Looking at the charge in this case, the potential maximum penalty, the probable plea agreement, the what sounds like to me a fair probability of a sentence in Charlevoix County. All of that together, with the lack of any kind of, I mean, there's nothing before me indicating Mr. Barnes is a flight risk or that he's a danger to the community or to public safety in some way. So for all those reasons, I do think a PR bond would be appropriate. And so the court will modify the bond as it relates to that only. All the other terms and conditions will apply. And then Mr. Travis, I guess, you know, I'll leave it up to you. If he doesn't, Charlevoix, for some reason, doesn't do something, you may want to consider revoking that just so that Mr. Barnes can continue to accrue credit on this file. So that's something that you can talk to Mr. Barnes about and make a decision to the extent that he's still got a hold and Charlevoix doesn't do anything with him. And then the court will set this for a plea hearing in about, at the court's next full motion day in about 30 days, status conference plea hearing.
Thank you, Your Honor.
And, okay, anything further on this file, Mr. Ziegler?
No, Your Honor.
Mr. Travis?
Nothing further. Thank you.
Mr. Barnes, did you have any questions at all?
No, sir.
Okay. All right, thank you. That's all for this hearing today. The court's going to disconnect at this time.
All right. Thank you, sir.
Okay, our next hearing's set for 11:15, so we'll take a break until that time.
What the fuck?
People versus Anson Evans, file number 234811. Like Mr. Evans is present here today. If I can have counsel put your appearances on.
Frank Ziegler, on behalf of the people, Your Honor.
Good morning, Your Honor. Michael Horowitz on behalf of Mr. Evans.
Mr. Horowitz, can you tell me the status of this file today?
We're still in the Michigan Supreme Court. I had filed an application for leave to appeal the Court of Appeals denial 4 or 5 months ago at this point. Last week, the Michigan Supreme Court issued an order ordering the people to respond to the application and giving them, I think, 28 days to do that. So that's where we're at.
Okay, Mr. Ziegler, anything new or different from your side?
No, Your Honor, I did receive that letter from the Supreme Court last week. I have a trial coming up on the 17th. I'll get my answer filed shortly thereafter. And I don't know how long the Supreme Court is going to take to make a final decision on the application.
Okay, so I guess Mr. Horowitz, would be my intention to set this out like 90 days. If we receive an answer or movement from the appellate courts prior to that, then the court will set it sooner, but otherwise that'll give us a control date. If we still don't have an answer at that point, Mr. Horowitz, I certainly would be open to stipulation to adjourn even that 90-day date.
Thank you, Judge. The 90 days would be welcome. And I just wanted to state, it sounded, it may have sounded negative how I phrased the Supreme Court ordering the people to reply. I think it's fairly atypical. They decide applications all the time without input from the prosecutors. In this case, I think they just wanted some additional input. So I didn't mean to suggest that the prosecution had in any way failed the file or anything.
Sure. Okay. All right. Mr. Evans, do you have any questions at all?
No, sir.
Okay. All right. Thank you. That's all for today.
Thank you, Your Honor.
Terry.
Yeah.
Is Miss Green present? Okay, Mr. Green, if you come right up to the podium here. Mr. Williams, are you able to hear me okay?
I can, Your Honor. Thank you.
So your client's approaching the podium. We'll go on the record in People versus Green. This is file number 255053. The record should reflect Ms. Green is present here in the courtroom. Mr. Williams is present by video by prior approval of the court. And Mr. Ziegler, prosecutor, is present here in the courtroom. Mr. Williams, can you give me a status of this file today, please?
I can, Your Honor. The people have been working with us to resolve this, and Ms. Green pay restitution in full. She needs through November to it's a little bit above 20,000 to secure those funds. And once that occurs, we have a misdemeanor resolution, but it's dependent on her coming through with restitution. And I'm just simply asking the court to just give us that extension. It appears that this will work out, and it's a good opportunity for Ms. Green as well. So.
Okay, Mr. Ziegler.
That's a fair statement of the resolution that Mr. Williams and I have been working towards, Your Honor. We adjourned back in August to give the defendant some time to come up with the restitution. It is about $20,000. I don't have an objection to another 60 days, Your Honor.
Okay.
I don't, but I can get
I just want to see if I find over Dave.
It was April 28th.
Okay,
April
that's right,
28th,
I'm getting
okay.
down there.
Okay, all right, so the court's gonna grant one more adjournment. And then if we don't have a resolution, I'm gonna at least have to get it on the trial docket by that time, because this case is gonna need to go to trial, prior to April. So, which I'm sure we can do, but I just want council to be aware that we're starting to run out of time here, from my point of view, as to timely resolution of the case. So we'll do one more adjournment. Ms. Green, just make sure that you stay in touch with Mr. Williams so that we're ready to go forward at that next hearing. Do you have any questions at all? Mr. Ziegler, anything further for the record?
No, Your Honor.
Mr. Williams, anything further from your side?
Just, the court can contribute the long delays to the defense. It's been our request, and we would take responsibility for those delays. Thank you.
Okay. All right, thank you. That's all for today. Mr. Williams, you're free to disconnect, and the screen, you're free to go. Thank you. Okay, next hearing is set for 11:30. So we'll go off the record until that time. Folks, which case are you here for? Okay. And your attorney's appearing by video, is that right? So you can come right up to the podium there then. And your last name's pronounced Garcia?
Yes, Your Honor.
Okay. All right, Mr. White, are you able to hear me okay?
I can hear you fine, Your Honor. Thank you for making an accommodation today as well.
Sure. Okay, so we're on the record now in People versus Jacob Garcia. This is file number 255081. The record should reflect that Mr. Garcia is present here in the courtroom today. His attorneys, Mr. White, is appearing by video by prior approval of the court. Mr. Ziegler, the prosecutor, is present in the courtroom. Mr. White, can you tell me the status of this file today, please?
Yes, Your Honor. For the record, Nathan White appearing on behalf of the defendant, Jacob Garcia. I've had an opportunity to speak with Mr. Ziegler regarding the state's position, and we've reached a plea agreement in this matter. We'd also asked the court to consider a Cobb sentence with respect to HIDA in this matter.
I don't engage in Cobb's negotiations. If you'd like to treat it as a Killebrew agreement between the attorneys, and I can advise Mr. Garcia further on how that'll work if I don't agree with that sentence, but I'd be willing to proceed that way, Mr. White.
Okay. Yeah, Your Honor. If the court would be inclined, we'd like to proceed under Killebrew with respect to this matter. The agreement, as I understand it, Mr. Ziegler, correct me if I'm wrong, but there would be an added charge for attempt, third degree fleeing and eluding. The defendant would plead guilty to that. The initial charge would be dismissed, and then we've discussed sentencing under HIDA in this matter.
So that's really the only agreement as part of the sentence would be the HIDA.
That's correct. Yeah, Mr. Garcia is 18 years old as well, Your Honor.
Okay. Mr. Ziegler.
That's all accurate, Your Honor. I would just note that for purposes of effectuating the HIDA, the fleeing and elude attempted third degree would be under the penal code version, not the traffic code version.
Okay.
So it would comport with HIDA, and I can give the clerk that back code.
Okay, do you have that?
I do. It's 750.479A3, and then in brackets, another A.
Thank you.
All right, thank you. Mr. Garcia, have you had an adequate opportunity to speak with your attorney about this resolution? Is that how you want to proceed today?
Yes.
You raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. You can lower your hand. Mr. Garcia, are you currently on any kind of probation or parole?
No, not yet.
Okay. You understand that the maximum possible penalty that you could face for this charge of attempted fleeing and eluding third degree is up to 2.5 years. You understand that?
Yes, Your Honor.
Okay. With that in mind, what is your plea to that charge today? So, sure. So, your attorneys indicated that you would be pleading guilty to that charge today. Is that how you want it?
Yes.
Okay. So I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all of those rights? Can you tell me what will happen to those rights by you pleading guilty?
Your Honor, may I have voir dire? My client wrote, it's in a way that maybe he would understand the question differently if the court's inclined.
Yep.
Mr. Garcia, do you understand that the question the judge has asked is that he's read a series of rights that you have. that
Yes.
by pleading guilty, you would be waiving those rights. Do you understand that you would be waiving those rights?
Yes, yes.
Thank
Okay.
you, Your Honor.
All right, thank you. Yeah, I'm just, Mr. Bercy, I'm just trying to make sure that you understand you have those rights and that you're giving those up.
Yes.
Okay.
Sure.
The plea that you're making today, you can only appeal by leave. That means if you wanted to get this plea reversed, you'd have to ask for the next higher court up, which is the Court of Appeals, to hear your case. And they could say no, and then that would be the end of any appeal. Do you understand that? Okay. Has anybody threatened you with anything to get you to plead guilty? Has anybody promised you anything other than what we've said here in court today?
No.
Is it your own free choice to plead guilty? Are you pleading guilty because you are actually guilty of this crime? Okay. So the other thing I need to advise you of, we've talked about HIDA as part of your sentence. You know, that's a probationary condition where this could come off your record if you successfully complete it. The lawyers are agreeing that that can be part of your sentence, but I'm not bound by that. And when we get to the sentencing hearing, if I disagree with that, or I don't think that that's appropriate, and I'm not going to follow that, I'll advise you of that. And then you would have the opportunity to withdraw the plea that you made here today. And you'd get all those rights that I said you were giving up back. Do you understand that?
Yes, sir.
I don't anticipate that's going to happen. Usually in cases where HIDA is involved, particularly with somebody who's young, like you are, at the younger end of the HIDA probation, I usually agree with that. So I don't think that's going to happen, but I want you to want to make sure you understand how that works. Okay.
Yes, sir.
All right. So the information I have indicates that this happened back on July 5th of 2025. Is that the correct time? On that day, were you present here in Kalkaska County?
Yeah, I was in Traverse City, Commerce.
You were driving through Kalkaska? Okay. So you were operating a vehicle at that time?
Yes.
And did you encounter a police officer in a marked police car?
Yes, sir.
And was that officer giving you some kind of indication, whether that was lights or sirens or hand gestures, to have you pull your car over? Did you fail to do that? Mr. Ziegler, are the people satisfied with the factual basis?
I'm satisfied here.
Mr. White, are you satisfied with the factual basis?
Yes, Your Honor. The defense is satisfied.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. White, are you?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. White, are you satisfied?
The defense is satisfied.
Mr. Garcia, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this added count of attempted fleeing and eluding. The court will accept your guilty plea. We're going to set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. White, your attorney, so you're prepared to go forward on that day. Before you leave here today, you're going to go across the way here to the building next door. You're going to check in with the probation department there for a pre-sentence interview. Okay.
Sounds good.
Mr. White, is there anything further we need to address from your side today?
Nothing further from our side, Your Honor. Thank you.
Mr. Ziegler,
Nothing further, Your Honor.
do you have any questions, Mr. Garcia? Okay, thank you. That's all for today.
Thank you very much.
Thank you.
Mr. White, you're free to disconnect at this time.
Thank you, Judge.
That's all I have.
Okay, thank you.
Thank you.
Good morning, Judge.
All right, good morning. It's just gonna be 1 second here. All right, I'm just gonna wait 1 second, Mr. Gurmurthy. I don't see opposing counsel yet signed in.
Okay, no problem, Judge.
So it'll just be a moment here.
We can just stay here. I'll just mute myself, Judge.
Okay. Okay, we've got both counsel connected now, so we'll go on the record in Blankenship versus Blankenship. This is file number 2514710. If I can have both counsel put your appearances on, please.
Thank you, Honor. Ravi Gurmurthy on behalf of the plaintiff, Ms. Dorothy Blankenship.
And good morning, Your Honor. Wendy DeVozo, appearing on behalf of the defendant husband, Donald Blankenship, and Mr. Blankenship and I are both present from my office this morning.
All right, thank you. We're on the record today for a status conference in this case. The last time we were in court, parties discussed some issues relating to a default and some other issues that were apparently resolved by stipulation. So, Mr. Gurmurthy, as it stands now, can you tell me where things are at and what we need to do for scheduling to get this finally resolved?
Excuse me, Judge, I think we should just do a pre-trial today. We've exchanged interrogatories, at least those are going back and forth. Ms. Blankenship did respond with her answers and send me some attachments yesterday, so we'll comply with those and send those to Ms. DeVozo. And then I think we should, in that scheduling order, refer this to mediation as well, with the hopes of getting it resolved. If it doesn't, I would think we would have a half-a-day bench trial.
All right, how much time are you asking for, Mr. Gurmurthy, for discovery?
I would think 45 days, Judge. We've already started that process, so I don't know if Ms. DeVozo thinks 60 would do with the holidays coming up. I wouldn't object to that. I know that'll put us right around Thanksgiving, 45 days, so I wouldn't object if we need to do 60 and then perhaps mediation right at the close of discovery within the 30 days.
Okay, Ms. DeVozo, what kind of time frame would you like?
I'm not opposed to the time frame that counsel's suggesting, Your Honor. The one thing I am concerned about is we need to appraise a marital home. And I'm worried, based on some of the overtures in previous hearings, I'm concerned that we're not going to be given access to that house to actually have an appraisal conducted. So 45 to 60 days, whatever the court thinks is appropriate is fine with me, so long as I can get in and get that appraisal done. We did exchange interrogatories. Both parties have them outstanding. Ms. Blankenship is currently late on hers, so I would hope to see something. I heard Mr. Gurmurthy say he just got answers. I'd love to see those in the next, handful of days, so we don't have to file additional motions here. And I think Mr. Blankenship's gonna have some answers due here imminently, that he's gonna finish up and get to me. Meanwhile, I think mediation would be fine, and again, I don't object to counsel's suggestion that maybe it's right at the close of discovery or right after, that we be ordered to complete that.
Okay.
Hopefully I answered everything.
Yep, you sure did. So
Great.
what we'll do then, based on what both counsel have said, I'll have discovery to remain open for 60 days, mediation to occur within 90 days. I will set this for a status conference at 90 days. If the parties are able to reach an agreement, then through mediation, we can use that date to take proofs and enter a judgment. If not, then we can discuss what issues remain. If anything was able to be resolved through mediation, and schedule further evidentiary hearings to resolve any disputed issues that remain. I will also put in the status conference order that both sides are to cooperate with home appraisal. That's something that, I mean, that shouldn't even be a question. Everybody should be cooperating with getting the numbers that we need to get this resolved. So I'll put all that into an order. The parties will also get notice of the date and time of that next status conference in 90 days. Mr. Gurmurthy, anything else I can address for your side today?
No, Judge.
Ms. DeVozo?
No, thank you, Your Honor, all set.
Okay, thank you. That's all for today. Both sides are free to disconnect at this time.
Okay, have a good day.
Thank you, Judge.
Thank you. That concludes our morning.